Okay, everybody, let's settle in for the last session before dinner today. And I just want to say that I am very, very excited to introduce you to the Honorable Tim Kaine, the junior senator from Virginia. Senator Kaine is my senator. You have Virginians in front of you here. So I just want you to know, though, but before Tim was my senator, he was my governor, and before that he was my lieutenant governor, and he actually would have been my mayor had I not moved up here to take this job away from Richmond, because he was the mayor of Richmond before that, and then way before that he has been my friend and my fellow traveler in social justice activities for many, many years. In his professional life pre-politics, Tim did fair housing work, and he also was a very active volunteer in homeless services. So he is a friend of ours, and you are here among friends. I am, as you know, we just talked about earlier today, Secretary Castro made a major announcement about HUD's very bold move on criminal justice reform and housing and fair housing. And I'm very proud that among the many issues that Senator Kaine takes on in the Senate, he has decided that criminal justice reform is one of them, and he has a particular interest in housing. So that's why we've asked him to come here and speak with us today. So please join me in welcoming Senator Tim Kaine.
Hey, thank you guys. Great. Wow. Good to be here. Well, I am thrilled to come and to talk to the coalition, but especially all of you on this great occasion where you're celebrating Sheila Crowley's dynamic leadership. As Sheila mentioned, we've known each other a long while. In fact, not only Sheila and I, but Sheila's husband and my wife, the four of us have done a lot of work together over the years. My wife was a legal aid lawyer, juvenile court judge, then foster care reform advocate, and now Secretary of Education. And Sheila's husband was the head of the preeminent fair housing organization in the United States, and then the head of the Virginia ACLU. And so whether it was homeless services, fair housing, anti-death penalty advocacy, foster care reform, the four of us had a lot of overlap over the years, and it's exciting to come, as I know you're getting ready this evening to celebrate Dr. Sheila Crowley's fantastic leadership. Give her a big round of applause, please. So what an exciting day. Was it pretty cool to have Secretary Castro here and hear him talk about the issues of criminal justice reform and housing? In one sense, and I want to work my way around and talk about the Supreme Court case that came down last summer and how it kind of opens up the path. What HUD has done is give just like really practical examples of what this newly clarified law means. They're not making new law, but what they're doing is they're really showing the depths of what the Supreme Court's decision of last summer meant, and that was a 5-4 decision. And if anybody tells you that a vacancy on the Supreme Court is not that important a thing, you know they're wrong. The Secretary Castro's presentation today of HUD's guidance is all premised upon the Supreme Court deciding by a 5-4 margin an issue that had been a live, open, and unresolved Supreme Court issue virtually since the Fair Housing Act was passed in 1968. So an editorial comment about the importance of having a hearing and having a vote up or down on a Supreme Court nominee. So you can vote no, and that's still consistent with advise and consent clause that is part of the Senate job description. But you can't say we will not entertain a nominee at all consistent with the job description in the Senate. So just a word about the importance of the court, because at the end of the day, it was the clarification of this in the Texas Department versus Inclusive Communities Project case that is opening up this path on criminal justice reform. I want to talk about criminal justice reform issues, but let me just tell you a little bit about my fair housing background before I got in office. I started practicing law in Richmond in 1984, and I was with a law firm with 12 people. Now, what happens when a pro bono case comes into the firm? They find the youngest person who has been there the shortest time, and they say, hey, can you do this case? And my first case, after I'd been at the firm for about a month, was a young woman who was almost exactly my age, and in many ways, almost a complete match for me, because I had just moved to this community and found my first apartment outside of, being a student in where I grew up. And that was a perfectly happy and exciting beginning of a life adventure for me. But my client, Lorraine, was doing exactly the same thing, out of college, in a new city, looking for a place to live. That should be an exciting and wonderful opportunity as you're a young adult and you see this great future open before you. But instead, she called a community that was advertised in the newspaper, an apartment. She was told it was vacant. She said, I'd like to come over at lunch and take a look. And when she got there an hour and a half later, the landlord met her and said, oh, I'm sorry, but it's been rented. And she just said, well, wait a minute, I just called you 90 minutes ago. Well, yeah, I know, but we had other people looking at it. It's been rented. So she went back to her office. Lorraine was African-American. She got a white colleague to call the same number and say, hey, I saw your ad in the paper. I'd like to come over. Oh, yeah, come on over this afternoon. Now, this was a case that was an easy case. It was the first lawsuit I drafted. I filed it in federal court. We settled it and won. But the thing that struck me was the awareness sitting across a small desk that Lorraine and I were quite similar, and that I had had this experience of finding my first apartment in a new city, and it was a positive. And it was kind of a positive experience that a young person would want to have. And she had had this experience that was not only a negative, but that was going to condition her to worry the next time she looked for an apartment, and the next time after that, am I going to be treated fairly? And it taught me taught me two things, really. It taught me that physical things are not important, relationships are important, but your house is more like a person than it is like a thing. Where you live is part of your definition, sort of who you are. And so the depths of her sadness and angst about this situation was because housing is so very, very important. And then the second thing it taught me is, as somebody who still to this day, I've never been consciously aware or even worried that I was discriminated against for anything. What a privilege that is, what a benefit that is to never have to second guess. If somebody treated me badly ever, it was either because they were a jerk or I'd been a jerk. It wasn't because they didn't like the color of my skin or my gender. And watching her and then all these subsequent clients that I represented over the course of 17 years of legal practice, about 65% of my law practice was fair housing cases, just again and again experiencing people either being turned away or treated differently because of their race or because of their disability. You just learn how it just creates this whole sense of doubt and second guessing that then goes out into the next situation and the next situation and the next. And I have been blissfully free of that, and learning that early in my legal career and then learning it again and again from my clients was a powerful thing. I ended up doing an awful lot of cases, many that were just straightforward, simple cases. Lorraine's was simple. It was just a clear violation of the law, and we were able to file a lawsuit and settle it. But we worked on a lot of complicated cases, too. I did cases about whether the portrayal of human models in advertising could establish a fair housing violation, and we established that they could. That if you're a community and you want to advertise to people and you just take a whole lot of pictures of whites and no pictures of anybody of color and you put that in, does that violate the fair housing law? And we established that under certain circumstances, yes, it does. I had a case in a small community in rural Virginia, Emporia, some of my Virginians know it, where a realty firm and a bank, and there aren't many realty firms and banks that are hometown there, conspired to take a home away from an African-American couple that had bought it by working a sweetheart deal to help somebody get it out from under them after their contract had been accepted and they'd paid a deposit. And so the issue in that case was that was a clear violation of the Fair Housing Act, but was it also a violation of the antitrust laws when you basically lock down a market and you make it uncompetitive for people who have skin color, who are minorities? Does the Fair Housing Law apply to mobile homes, which in Virginia are taxed as personal property, not realty? That was a case, that's an easy one, but I had to take it up to the Virginia Supreme Court to win that on a 4-3 vote. Does the Fair Housing Law trump not only restrictive covenants, but local zoning ordinances when it comes to the permitting of group homes for folks with developmental or mental disabilities. We had to take that one to the Supreme Court and narrowly win it. But then the last case I worked on that was 6 years full-time was whether you can establish a claim under the Fair Housing Act for the differential treatment of people in the issuance of homeowners insurance policies. If you write fewer policies in minority neighborhoods, or if you write them with worse coverage at higher rates, can you establish that as a violation of the Fair Housing Law? So this is what I did for 17 years before I got into statewide politics. And the issues of intent, discriminatory intent, but also disparate impact were huge. Now let's get to the topic of criminal justice reform. The Supreme Court case of last summer was extremely important in this area. I have roundtables with folks who have been sentenced and been in the criminal justice system often in Virginia. I had one just in this calendar year. I've had one in Hampton Roads and one in Richmond to talk to people about the challenges that they face. And of course the challenges are numerous, from voting disenfranchisement. Virginia has the toughest voting disenfranchisement provision in the country. Virginia and Kentucky do, but access to all kinds of issues, ability to get employment. That's why I've been such a strong supporter of the Ban the Box movement. But housing is also an absolutely critical issue. And go back to what I said about my first client. If housing is really a fundamental part of who you are, then if you believe in rehabilitation, but you're going to constrict and restrict somebody's ability to have housing that's dignified or housing that's equal to others, then you're basically putting a lid on their ability to rehabilitate, and it's so very, very important. So the case last summer, I'm sure you talked about it, was not a case dealing with the criminal justice system, but it was a case dealing with this question of disparate impact and intent. And it's funny, this dispute about the Fair Housing Law has been a dispute since 1968 when it was passed. There was an assumption, and most of the circuit courts that had grappled with the question, possibly all, had eventually said you could establish a fair housing claim. You didn't need to show intent. That would be helpful. But what you did need to show is disparate impact. And yet, even though the circuit courts were ruling that, there was still this lack of clarity about whether the Supreme Court approved it. And I know for litigators like I was doing these cases, not being sure that you could win a case on disparate impact made it very difficult to bring one. If you were going to bring a case as a practical matter, I know we've got folks from who are attorneys here from Virginia and elsewhere. If you were going to bring a fair housing case as a practical matter, you really wanted to find intent because you weren't sure at the end of the day whether a case that was based on impact or effect would be enough. And the 5-4 opinion of the court clarified that. And I'm sure that you kind of talked about what you have to show. What Texas Department versus Inclusive Communities Project said was you got to show this. You got to show not just statistically that there's a disparate impact, you know, that in this case that tax credits for low-income housing were proliferating in being placed in minority neighborhoods and not placed much in white neighborhoods. Just the statistics isn't enough. You have to link those statistical disparities to a policy, and then you have to show that that policy is arbitrary, unnecessary, or unreasonable, and that there are other means to try to accomplish the legitimate objective of the government agency in that case, or of a private sector company if you were to pursue them. So by this 5-4 decision, we've now made very, very plain that a disparate impact case is sufficient. And that's what the HUD guidance today kind of fleshes out. What does it mean to show disparate impact, and what should housing providers, governmental or private, stay away from when it comes to criminal justice? I want to talk about the aspects of this HUD guidance, disparate impact, and then a little bit discriminatory intent, because sometimes things that seem facially neutral are not facially neutral at all, and the HUD guidance talks about that as well. And then the last thing I'll talk about before opening up for questions is, hey, what's the likelihood of criminal justice reform? Because that's criminal justice reform and affordable housing. Let's talk about how to use the Fair Housing Law to open up housing to people who might have been engaged or involved with the criminal justice system. Let's talk about that under the new status quo as has been laid out by the Supreme Court and HUD. But then let's talk about the big question, which is, when might Congress do meaningful criminal justice reform? Okay, so what the HUD guidance basically says is this. And they stress this, we're not creating law. This is just a straightforward application of the new Texas versus Inclusive Communities Project case. First, if you, as a housing provider, make requests and make decisions based on arrest data, that is going to be viewed with high suspicion in terms of a disparate impact case. We do know there might be some jurisdictions in the country where that wouldn't have a disparate impact racially, but in most jurisdictions it would. And HUD has pretty much said if you use arrest data that didn't lead to a conviction, you're using a policy that is essentially arbitrary and unreasonable. It wouldn't have any justification. And so arrest data purely, they almost said that could never be data that would get over a disparate impact test in a case. So that's the first thing they do, and that's extremely helpful. The HUD guidance suggests that if you exclude people from housing or treat them in a more negative way because of a prior conviction, that is also likely to be highly suspicious if there is not some distinction between when was the conviction, what were the circumstances of the conviction, what was the crime in the conviction. Just trying to wall off people based upon convictions will likely flunk the disparate impact analysis, and HUD has made that very clear. And again, that is extremely important. So that's not to say that a housing provider couldn't have some, prior conviction in some narrow and carefully defined way, and it might get over the hump. But this guidance today pretty much says to a housing provider, if you use prior conviction, you're going to be really under a microscope for purposes of how HUD interprets the Fair Housing Act, and you leave yourself open to the compensatory and punitive damage provisions of the Federal Fair Housing Act. The Federal Fair Housing Act does specifically say that convictions of manufacturing or distributing drugs under the Controlled Substances Act, those are ones that housing providers can take into account. And some of that is because sometimes the manufacturing of drugs takes place in dwelling units, and there can even be a safety, meth labs with fire risk and things like that. So that is still going to be something, even under a disparate impact analysis, that if it's drawn carefully enough, a housing provider is likely to be able to use. But the ability to take away use of arrest data, and to take away in most circumstances just raw use of conviction data as the reason for a no or for less favorable treatment in housing. And remember, when we're talking housing, we're talking rental, we're talking sale, we're talking financing, we're talking homeowners insurance, we're talking services. The definition of housing under the Fair Housing Act is very broad. It's not just the making the deal to rent or to buy, but it's also all the other aspects of it that come along with home ownership. If you take away arrest and you take away conviction in most instances, that is an enormous plus for people who've had involvement with the criminal justice system and should open up a lot more opportunities for them. Say that let's say now that a housing provider has a very careful and narrowly drawn provision with respect to certain types of convictions, and maybe even just limited to manufacturing or sale of drugs as is listed in the Fair Housing Act. Say that a housing provider or government agency or private sector has that kind of a rule and tries to disqualify people if they're engaged in that. You can still go after them if they don't do it in an even-handed way and apply the same rule to everybody. And this is a very, very fertile field for activists and advocates, and certainly for fair housing lawyers. We used to always say it was kind of really using disparate impact to demonstrate actual discriminatory intent. I'll give you an example that we used in my case against Nationwide Insurance on a homeowners insurance case. We did studies, and we didn't have rock-solid evidence of discriminatory intent in the differential treatment of houses in minority neighborhoods. We later got boatloads of evidence about discriminatory intent in discovery, and we put on a case and proved that there was discriminatory intent, and that's why at the time when we won the case, it was the biggest civil rights jury verdict ever in American history, because the evidence of intent was so sharp that the jury said, you got to be kidding me. You're a massive company and you're doing this in 1998. But we didn't have that when we filed. What we had was a set of tests involving homes, some in minority neighborhoods, some in white neighborhoods, and the homes were matched for value and they were matched for age. So a common example would be tests would be undertaken with respect to two homes, each that are about 65 years old. And if you're calling to get a quote for insurance on the home in a white neighborhood and you get a quote, and you're calling in the African-American neighborhood and you're being told we don't issue insurance on homes more than 50 years old, and this happens not once, not twice, but dozens and dozens of times in different neighborhoods, white and black neighborhoods with homes that are of the same age. Now, a company, if it wanted to, could potentially have a rule if they applied it even-handed and if there was some actuarial justification for it. But even if there was actuarial justification that a home of more than 50 years, for example, was more of a fire risk or occasioned a higher premium, even if there was justification, if they're applying it differently to people who live in a white neighborhood than people who live in a black neighborhood, it's not even a discriminatory effect case or a disparate impact case. It's an intentional discrimination case. And so for those of you who are involved in this work, if you're working with folks who have had engagement in the criminal justice system, this doctrine says, okay, look, they can't just use the arrest data against you if it hadn't led to a conviction, and they probably just can't use conviction data against you unless they've really carefully defined it. But you've got to go further. Even if they do carefully define it in the most narrow way, there's always the possibility, and you need to look at this carefully, that they're applying it differently based upon race or based upon national origin or other protected classes. And that's something that you can sometimes get at through testing pretty quickly. And sometimes you don't even have to do tests. You can just kind of become aware in the interaction that something funny is going on. And all of you do this work. You've trained yourselves to have your antenna go up when something doesn't seem right. And often these things are not applied in an even-handed way. So that's what's really fantastic about the Supreme Court's opinion, is it resolves this unresolved issue, which we all thought, from the very beginning, all the advocates, we thought disparate impact would be enough. But now the Supreme Court has said not only, yes, it is enough, but they've described what it means, and now HUD has given you the guidance to be able to advocate for your clients and your customers as you help people who've been connected with the criminal justice system find the housing that they need. Okay, now let's talk about the real issue, which is criminal justice reform. In one sense, we're in a moment where criminal justice reform has suddenly become somewhat bipartisan. And there's a lot of reasons for that. The Dems have traditionally been strong for criminal justice reform. When I was a Democratic lieutenant governor and governor of Virginia, we were always trying to change the state laws to more widely, to eliminate the permanent disenfranchisement of felons, which has been a part of the Virginia Constitution for years. Been trying to change that, but we were always having a hard time getting the support of colleagues in the other party. And it was also the case that the whole mandatory minimum, 3 strikes you're out, get rid of parole, tended to be partisan as well. But the good news is, and I'm going to give my Republican colleagues credit on this, for a variety of reasons, some spiritual, religious, the second chance, the evangelical-minded notion of a second chance is a pretty powerful spiritual concept. So there's some altruism and spirituality that underlies this kind of change in heart. There's also some just hard statistical analysis. We say we're great, but if we're great, why do we imprison so many more per 100 or per 1,000 than other nations? Do we either believe we're great or do we believe we're the worst people on the planet? And we have to imprison more than anybody else on the planet. Which do we believe? Well, we believe we're great. Okay, then we should do something different. And then the third thing is just the fiscal realities of what's happened. If you look at city and county and state budgets, federal budget, since the mid-'80s, inflation adjusted, a whole lot of things have not moved very much in terms of per capita expenditure on items. I used to say to my Virginia colleagues when I was governor, since the mid-'80s, we've had this changes in state expenditures. We spend below the national average per capita on everything except one thing. What is it? And they would, usually guess a couple things wrong, and then they'd say incarceration. I'd say, that's right. Incarceration is the area where we spend more than the national average. We spend less than the national average on everything else. And in the desire for fiscal austerity, and let's be, if not austere, at least let's be smart, that is also a powerful argument with many Republican constituents. And so what we see is a moment now where I think there is true bipartisanship in looking to do criminal justice reform. So far, that's been rhetorically the case at the federal level. It hasn't yet really produced an outcome. I don't say the rhetoric is insincere. I think it is actually sincere. And the rhetoric is producing some positive outcomes in states. I noticed when I was governor, for example, I had to make painful budget cuts. I was the only governor that left office with a smaller budget than when I started. That wasn't what I wanted to do. I didn't put that on my bumper sticker when I ran for governor, I can assure you. But it was a recession, and, it was just, that's what it had to be. But as part of those cuts, we closed a lot of juvenile justice facilities and state prisons. And I didn't get a lot of squawking from the other side. People were like, well, it's a tough time. Fiscal austerity is important, so sure, if other things are we got to cut that too. And you see in other states sometimes the closure of institutions for the same reason, and in other states even more far-reaching processes to change sentencing laws and to move toward a lesser criminalization or decriminalization of offenses like drug offenses. So that's a positive. At the federal level, though, what we've seen, again, rhetorical sincerity and a bipartisan moment. This is something that Speaker Ryan has talked about. When he was asked at the beginning of the year, he said, somebody asked him, what might you be able to work on with President Obama in the last year of an Obama administration, recognizing that presidential years maybe not a lot gets done. This was one of the things he mentioned, and he's sincere about it. But while there's been sincere rhetoric, we haven't yet gotten over the finish line anything that I would call a meaningful reform. And my prediction is this, that the battle about reform this year will be a battle about sentencing. It's not going to be a battle about racial profiling. It's not going to be a battle about issues of, what are correct and incorrect policing techniques. It's going to largely be a battle, or even about the definitions of crimes, except possibly decriminalization of drug crimes. It's largely going to be a battle about sentencing reform. Now, that's good. We ought to have a dramatic reform of sentencing. We ought to de-escalate the trend toward mandatory minimums or the elimination of parole, the incentives for people for good behavior. We ought to reduce disparities in sentences between things that, like the crack cocaine disparity with other kinds. These are sentencing disparities that are huge. We ought to move away from the mandatories and give judges more discretion within certain guidance. So I'm for all of that. But I just want to say, the title of this is Criminal Justice Reform and Affordable Housing. There's a lot of criminal justice reform that even in the bipartisan moment isn't yet part of the bipartisan discussion. But I do believe that there is sincere interest on the sentencing reform thing. There are sentencing reform bills that are pending both on the Senate floor and in the House. They're different. I think most of the advocacy community tends to like the Senate version better, but it's not without controversy. Some of the civil rights groups really like the Senate version, but some are standing back and saying the Senate version has a lot of good in it, but there's also some provisions with potentially new mandatory minimums that we have to scope out to see whether the damage that those may do may offset the good that the other provisions do. So we've got this bill on the floor that is bipartisan, and it is my hope that we're going to take it up and tackle it this year. And I do think we have an opportunity to do it and to get something. And I know that the president would obviously be thrilled if we could put a sentencing reform bill on his desk. But I'll just conclude and say, even if we do, let's not lose sight of the fact that sentencing reform isn't the entirety of criminal justice reform, that there's so much more to the criminal justice issue from, as we saw in the cases over the summer, police activity, prosecutorial discretion, why prosecutors treat some cases one way and some cases the other way. Those aren't necessarily touched by sentencing reform, so there will be more to do. But on the the end of the day, let's finish back on a positive. This, on the one hand, we advocates assumed for a long time that a disparate impact case, that you could probably win an FHA case under disparate impact. But the difference between assuming we could but not being 100% sure and now being 100% sure, and now having the HUD apply that guidance to common and really practical questions about people's criminal background record, I think will be enormously helpful to advocates making the case. But you guys aren't here for you. You're here for the people you're advocating for. It'll be enormously helpful to the huge number of Americans who have had a connection with the criminal justice system but desperately want to, get right and be completely rehabilitated and be fully contributing members of society. So with that, I will stop. And Sheila said I could maybe take a question or two, and I'm glad to do that. Thank you.
So you all know the drill. Is my mic on? Turn it on. Okay.
Yeah, there you go.
Am I on? Yes. So you all know the drill. Stand up at either mic, and we're asking questions, not statements. Questions, not statements. He's not
Try telling that to a senator who's supposed to ask a question at a hearing. We make statements instead of asking questions all the time. But I'm glad that Sheila said it.
You're not a good role model, then. I see that. Okay. Just so you know, the senator has to leave by 4:45 at the very latest, and he wants to spend time with his constituents right here before he goes. So we're going to take just a few questions, and then we're going to have some time to do that.
Great.
So let's start over here with Dee Dee from Charlottesville.
Hi. The question that I have for you is, how do we stop this madness with the police officers and how they are recycling our people in and out of the system, using people that get arrested, and you turn around and use them as snitches against other people? That seems to be a big problem. I'm not even going to call the organization in my town, or maybe I should, which is called JADE, Jefferson Area Drug Enforcement. How do we stop this madness when a person gets arrested for something simple, and you turn around and you use that person to set up other people, and then that person turn around, you use, each person that you bring in before the judge is being used, so you're constantly recycling our people in and out of that system, and you're making tons of money off of them. I think is crazy, and I think something needs to be done, because I'm so tired of sitting in the court system knowing that our people are being used to do the police officers' work. So I feel like if our people are going to be used to do the police officers' work, then we don't even need the police, because we have so many people that are informants now. So how do we stop that madness?
Dee Dee, that, you know what, the reason I come to do things like this is if I'm honest, I always get asked something that, well, I haven't really thought about it like that. So this is a really good reason for me to be here. So the point was, and I did not do criminal defense trials as an attorney. I know the system pretty well, but I'm not the expert on this. But Dee Dee's point is, part of most sentencing rules, federal and state, is you get a little bit of benefit in your sentence if you are cooperating. And the evidence of cooperation is usually, are you willing to tell about somebody else's criminal behavior? And so your question is sort of like, as we look at other pieces of criminal justice reform. So say we do some sentencing reform, but still the police reform issues, and maybe this could even be a sentencing reform issue. If we give too much benefit to telling on others, then we kind of run this informant society that has maybe some civil liberties components as well as a discriminatory impact. So I'm gonna take that, and as we grapple with criminal justice reform issues, I'm just going to remember your question and remember to look at it that way. I will say this, Sheila knows this well. I was a city councilman and mayor at a time when Richmond had one of the worst violent crime rates in the United States. We were second highest homicide rate in America when I got elected to city council in 1994. We ended up dramatically dropping violent crime. Richmond is a wonderful city, and the crime rate's a lot lower. We're not doing anything we couldn't do better. But it was interesting. Richmond used a model to do this that other cities used in the 1990s, and we called it broadly community policing. And the idea was to make police officers very, essentially trusted members of the community that you wouldn't mind coming up to and saying, hey, I think there's a problem in a vacant lot. Can you help us out? Or something's going to happen tomorrow. Can you be here? And you really work to build up the ties between members of the police and the community. That was a model that wasn't just a Richmond model, and it helped us. It helped other cities too. But then it seemed to be about the beginning of the 2000s, there sort of changed the kind of philosophical mentality. There was this sort of broken windows theory. You crack down on the small things and you crack down on them hard, and then that'll keep you from experiencing the big things. And instead of focusing on the relation between the police and the community, we focused on a more punitive attitude, come down like a ton of bricks on the smallest things, and then that will make your community safer. It coincided with the attacks of 9/11 where, we need to give police departments a whole lot of, super intense equipment, riot gear, et cetera. And there was kind of a militarization of the police, and the combination of that militarization post 9/11 and the adoption of this broken windows theory to replace what had been the community police model worked in Richmond, worked other places too, but the model changed and it became a much more adversarial kind of us against them model. And I think we learned enough about the success of a community policing strategy that why don't we go back to doing what was working instead of being overly kind of on the adversarial side. So there are police reforms as well implicit in the question you ask, and that's something to do real criminal justice reform we have to pay attention to. And sharp-minded police leadership get this. There are those who don't, but there are a lot of people who do get this, and they understand that that's the better way to go.
Thank you.
So I just want everybody to recognize that Dee Dee just asked a question of her senator. He said, you have told me something I hadn't thought about, and I'm going to take it back and think about it and do something about it. So,
Thanks, Dee Dee.
Thank you, Senator Kaine. My name is Lashadian. I'm with the McKinney Housing Authority, McKinney, Texas. You had said something that Speaker Ryan seems sincere in the reform of criminal justice reform. And we know that Bill Clinton last year had apologized for his role in mass incarceration. The rhetoric seems sincere, you had stated, but wasn't it Ronald Reagan that said, let's make it appear as if we're doing exactly not what we're doing, right? To summarize. So although it seems sincere, I would like you to address the pipeline, because we're talking about housing, the pipeline from poverty and homeless to prison, and then also address the conflict of interest that these judges have interest in private prisons, that they send homeless and poverty people to prison to build the interest in the stock in the prisons that they own. Thank you.
Yeah, and so on the second one, what I'll do, and I've got a couple of staffers here, so what I might want to have is get information about that second point to my staff. The conflict of interest would not, I don't think that would be an issue in the Virginia system because of the way that judges are, appointed. We don't have elected judges who get campaign contributions, from people who might have a particular interest in what the sentencing alternatives are.
Yes.
Every state chooses judges different ways. Some it's a gubernatorial selection, some it's a merit panel, some it's a legislature, and some it's elected. And I would be afraid to practice in a state that had elected judges.
Yes, sir.
I mean, my whole practice was civil rights. I was always sitting with the person that didn't have any money, the two of us usually by ourselves at a table, where at the other table there was a whole lot of people with a whole lot of lawyers. And so it was hard enough to do the cases, feeling like you're pushing a boulder uphill in the system that we have sometimes. Yes, but if you were in that situation where the judges were very aware of who had contributed what to their campaign, I mean, I would find another profession or I would move. But you don't have that option. You got a justice system and you got to make it work. But I will try to follow up on that issue and see if there's anything that could be relevant at the federal level to that.
Yes, sir.
And then the first half of your question, tell me again the first half.
The first half of the question is about the pipeline from
Yeah.
poverty to prison,
I mean,
from
it's-
homelessness to prison. It doesn't seem that, they may seem sincere, but
Yeah,
if we
yeah.
stop that pipeline, then we stop the money flow. We stop the money to the policing. We stop the
Fair
money
point.
to the cities.
Now,
and
fair
those
point.
things.
Look, judging somebody's sincerity, we're all gonna be the judges of that.
Right.
But I do believe, and I've seen enough action at the state levels on this issue to believe that there is an openness now to reforms. Now, they may be more modest than the ones we want to make, but instead of just automatically now everything has got to be increased punishments and throw the book, now they're starting to be, for this combination of evangelical and the data makes us feel bad as we look in the mirror, and the cost. And don't underestimate the power of the austerity crowd on the Republican side who are like, well, wait, why would we spend unnecessary money? I mean, there is a driving principle for many, which is take fewer tax dollars out of my pocket if you can. And if you're wasting money on anything, then you're going to find a constituency that says you got to be able to be more efficient with this.
Yes,
and
sir.
we can definitely be more efficient about the way we use criminal justice dollars.
Yes, sir. Can I schedule some time with you, because apparently I have a lot of questions that.
Well, here, I'm going
Get with them.
to get my staff to come give you information.
Please
So-
do, because I had one more thing about life sentencing, because we get convicted of crimes as black men, and we serve our time, and then we're hit with a life sentence for crimes that do not carry a life sentence because they have. Can we get a federal law that says you have so much time after a conviction, and then because what these applications for housing do says, have you ever been convicted?
Right.
And so for the rest of my life, I have this conviction or whatever the case is, and I'm unable to get housing. So if we can address that at some point, but I'll get with your staff. Thank you.
Yeah, thanks, please.
Thank you, Senator. Hi. Kevin Martone from the Technical Assistance Collaborative in Boston. So
Kevin.
I guess the question is, can you help us think about the messages that we need to shape with our congressional delegations and our state legislatures, right? So criminal reform, criminal justice reform is right? Getting less people in criminal justice systems, fewer dollars in institutional care, et cetera, et cetera. But the flip side of that is, there's got to be social service programs, affordable housing for the people that we're talking about here. The largest residential provider for people with mental illness in this country is the criminal justice system.
Yeah.
We're talking about people with
Oh,
mental
yeah.
illness. We're talking about people with addictions. So when we're talking about this, we're talking about affordable housing and social service programs
Right.
and health insurance coverage and things like that aren't always politically palatable in these conversations. And how do we shape that? How do we convey that message to our elected officials, so that criminal justice reform can be a reality?
Yeah. No, that's a fantastic one. Well, look, I think the reason we're in a moment where there is opportunity and there are some successes going on at the state level is you are doing a pretty good job on this. I'm not just saying that there's sincere interest on the other side because they woke up one day and said, okay, wow, we want to do criminal justice reform now. No, look, you've been making the case about how counterproductive it is that we're the over-incarceration society, and you've been making the case how counterproductive it is, this mass disqualification of voters. The new Jim Crow, Michelle Alexander's book, such a powerful book. So advocates have been making a case, and that's been helping. But I'll tell you so I think the economic argument, the cost argument is really important. I think the moral argument is really important. An argument that I don't hear enough that I would really like to hear as part of a criminal justice reform debate is kind of a recidivism argument, which is, just on average, what is the likelihood that somebody who's been in jail or prison will commit I'm sorry, I don't mean recidivism, I mean crime prevention. It's going to connect to recidivism, but crime prevention. What do you want to do? Would you rather prevent crime or punish crime? If you just had to pick one, everybody would say prevent. I mean, the most conservative person would say prevent. What should be the number one goal? Should be prevention, right? Absolutely. Okay. Now let's look at groups of people. What is the likelihood that somebody who's never been connected to the criminal justice system, never had an arrest, will commit a crime? The likelihood that somebody who has been convicted who has had a connection will commit a crime. Well, obviously, it's like this. If somebody has any previous history, they're going to have a higher likelihood than the group that doesn't. So if you wanted to prevent crime, wouldn't you spend You know, it's like, why wouldn't you go to the most likely source of it? It's like if you're doing budget cuts at the federal level, you don't go to the items in the budget that cost nothing. You go to where the big items are. So similarly, if what you're going to try to do is prevent crime, then reducing the recidivism rate of those who've had an engagement with the system is the best thing you can do to make our society safer. That's where you ought to be spending your resources. And so a lot of you, I know, work in multiple areas, including like offender aid and restoration and offender services and training of folks in jails and prisons so that they'll have a little bit better chance of, getting jobs or things when they leave. It's incredibly important. That's why, again, why Ban the Boxes is so important. We have to take the group that is more likely to be involved in crime and think about the right strategies and spend resources to bring down that likelihood. And that's the best way for us all to be safe. So I think an argument that's based fundamentally on the top goal should be prevention. And if it's prevention, then more resources on those who are in the system is the best way to go after prevention. So I don't hear the argument made that way that often. And just as a layperson, not as an expert, I think that's a powerful one. I'll tell you an interesting prevention thing. It's fascinating. I had a round table. This is like Dee Dee's question, where you learn something you didn't know. And look, you should always want to be smarter when you leave something than when you walked in. So you should always be looking for something you didn't know. I did a round table in Richmond about employment issues, not housing, but employment. And this guy had a fantastic job training program for people coming out of prison. And he said, here's the problem. Ban the Box gets in the way of all my people. They got to list what their criminal background is, and it keeps them from getting jobs. What I decided is this. I'm going to train them to be contractors. If they can get a Class A contractor license, which, it takes discipline, but it's not impossible. You can get that. Nobody asks a Class A contractor to fill out an employment form where they got to list their criminal. They ask you, give me 5 customers you've worked with, and let me see if you're on Angie's list, what they said about your work. The Ban the Box is like irrelevant in the contracting space. If you can train yourself in a trade, it doesn't even have relevance. It's relevant to getting employed by somebody else, but if you're starting your own business as a contractor, it's completely irrelevant. And so that's kind of an interesting way around some of the challenges, and I wouldn't have thought about that until I sat down and listened to this guy. So anyway, that's a little bit off the subject that you asked the question, but I would say let's be about prevention. That's what we're about. Everybody's for prevention, and the work that you're doing, put it in a prevention mindset, and you'll be real persuasive.
So there's 3 more people standing here. I'm going to ask you to each state your question very quickly. We'll state your question and then your questions quickly, and then we'll see if the senator can give you quick answers.
Carol Brown from Cincinnati, Ohio. My concern is with juvenile system. Mm-hmm. In Hamilton County, we have where if a juvenile gets arrested and if they're put away, the parent, if they're working, they must pay child support. They must support that child, pay for that sentence and while they're in there. Mm-hmm. And it's taken out like child support, which takes away from them being able to pay their rents a lot of times.
Right.
And a lot of them are being faced with having to move because this money has already been taken up out of their check.
I hadn't heard of that, so that's important to hear. So,
my question is, hi, I'm from Austin. My name is Rachel.
Thank you.
But my question is, what about those who don't even have a criminal background that get discriminated against just because?
Yeah.
And also, for those who are aware or not aware, what can we do in the future for like HUD properties that are privately owned that will not accept you if you have a market rate eviction? Because there are some that will accept you, but then there are some that don't.
And these would be like privately owned, but they're using
but they still
housing
use HUD
voucher or
vouchers or whatever.
Okay. I'm gonna. So now the last question, and then and then I'll come back to both of these.
One is, will the National Low-Income Housing Coalition track any lawsuits in regards to people that are discriminating on criminal records? And then the second goes to what the other young lady was saying in regards to folks that are on this. I'm Sue from Minnesota. Folks that are on probation In Minnesota, a third to a half end up being reoffending because they can't afford their probation costs, whether it's UAs or other things. How can we address that in the reform?
Oh, yeah, it's great. So the two of the questions were really criminal justice, and one was more broad anti-discrimination. So I'll take the criminal justice ones and the anti-discrimination. This cost issue is massive, and this is a really important criminal justice reform issue. Here's one. In Virginia, ex-offenders, if you're done but you haven't finished paying off all your court costs, you were barred from getting a driver's license. So, like, what kind of job are you going to get? And then you don't get the job and you can't pay off your court costs, and so then you continue to kind of be under the burden of that. But also you're not paying your taxes. You're not doing things that would be good for society. So there are a lot of consequences to unpaid costs where we additionally burden and stop people from integrating back into society. And I think that is a very fertile area for reform. Those tend to be very state-specific rules, so there's probably no one-size-fits-all answer to them. It's really important. On this point about the juvenile justice thing, I hadn't heard about this deal of dunning parents for their kids' involvement in the juvenile justice system. Okay, so, and my wife used to be a juvenile court judge, but I don't think that was a feature of the Virginia Juvenile Code during the time she was doing that, but if it is now, that is, what they say, the sins of the forefathers shouldn't be visited upon the next generation, and it really isn't fair financially to take it the reverse, unless the parents have been involved in the criminal activity or something, but you're saying that that's not the case, so that's important. And then finally, on the issue just about discrimination generally, look, and the housing questions, there are great housing organizations, and there's great organizations from Low Income Housing Coalition to the National Fair Housing Alliance. Now, I know the coalition and the National Fair Housing Alliance have a good tie, and so even if there isn't any connection with the criminal justice system, there are fair housing organizations out there, and the coalition is connected in with the National Fair Housing Alliance and other local organizations that can help battle those issues. So I could say and answer a lot more, but I got to go vote. And I really appreciate the chance to come. And again, congratulations to Sheila, and thanks. And then, are we Virginians maybe going to take a picture together? Take a picture right here? Okay.
Yeah, and then we'll give you a present, but you don't need to worry about it. Okay.
Is that one for me to take?
Yes, it is.
Can I do the
Just
Take your folks, move up here really fast.
okay, while the Virginia people are getting their photo op, just a couple of points. Can I get your attention just for a moment? So here's the deal. Dinner tonight is at 6:30, and as with all of these things, we have a very tight schedule, so please be in here and seated right at 6:30. We do have a book signing opportunity with Barney Frank. So if you want to buy a book before dinner, come a little bit early. But come early so you can get your book and be seated at 6:30. And then tomorrow, when you do your Capitol Hill visits, we're asking the state delegate leads to please come back and report back on your Hill visits right here in the Hermitage room. Tomorrow there's no breakfast or lunch. You're on your own for that. In the Hermitage room right across the hallway, from about 2 to 5. If you can come back and report on your Hill visits, that would be most helpful. Thank you. We'll see you tonight at 6:30, right here.